At the Jewish Fertility Foundation's Michigan Family Protection Act webinar, along with the Michigan Fertility Alliance. We're very excited to have you tonight. Just so you know, this will be recorded, but none of the participants will be seen, so please don't worry about any confidentiality issues. I am Danielle Gordon. I am part of the Jewish Fertility Foundation Detroit team here. And we just want to let you know a couple resources before we get started. We have a monthly support group that meets on Zoom, and there will be a link placed in the chat where you can find more information on all of this. We have a local in-person group that is going to be happening on April 7th in the community. This evening, right after our webinar at 8 p.m., there is a National Gestational Surrogacy Support Group that meets monthly, in case anyone's wondering. And again, information will be put in the chat for you. And a couple other resources we have a fertility buddy program where anyone who's actively experiencing infertility can get matched up with a veteran. So if you know of anyone on either side who'd be interested, please reach out to Taylor Weintraub at the end, and we'll put her email in the chat. And then just so you know, follow Jewish Fertility Foundation on social media. We're planning a national webinar on surrogacy later in this year. And again, our new Detroit manager is Taylor Weintraub, and her email is in the chat. Just a couple of housekeeping. If you have any questions, please put them in the Q&A box. We will be doing Q&A later after the presentation, and we are going to get started. So first, it is my pleasure to introduce you to Representative Samantha Steckloff. She proudly represents the 19th District of Michigan. She is currently in her third term in the House, and during her time as a legislature, she's been able to be a really big champion for women's reproductive health. She was the main sponsor for this Michigan Family Protection Act, and it was signed into law in 2024. And this law repeals an outdated ban on surrogacy, protects children born via IVF, and ensures that LGBTQ+ parents are treated equally under the law. At age 31, Representative Steckloff was diagnosed with breast cancer, making surrogacy one of the only ways for her to have a child. This issue is really very near and dear to her heart, and she will continue to be an advocate for people that can't advocate for themselves. And so it's an honor to introduce her, and we are so grateful and thankful that you are here with us this evening.
Thank you, Danielle. Good evening, everyone. I'm Representative Samantha Steckloff, the 19th District. It is parts of Farmington Hills, Bloomfield, Franklin, Beverly Hills, Birmingham, Bingham Farms, and Southfield. So it's kind of a wide, long district throughout Oakland County. At 31 years old, as Danielle said, I was diagnosed with breast cancer. And I think the most difficult thing about that diagnosis was finding out that my family planning was no longer up to me. And with the laws and the outdated laws we have in this country, adoption was nearly impossible for me, if not impossible. I cannot carry my own child, and surrogacy is the only way that I can grow or expand my family. So the laws in Michigan since 1988 have had a criminal ban on surrogacy. We were one of only 2 states that had this ban. And last April, we were finally able to get this bill signed into law by the governor. And actually just yesterday, I had a memory pop up that it was the 1-year anniversary of this amazing package passing through the Michigan Senate. This was a labor of love. So many people on this call, specifically Stephanie Jones, we really worked together hand in hand. It was one of the first bills that we've seen go through the Michigan legislature that was actually driven by advocates. And I think that's a really important part because of the way that this legislation was crafted. It was crafted very delicately, it was crafted very precisely, and that is why we are going to be the leaders in this space. So many other states are now looking to Michigan to find out how they can update their parentage laws. And we'll go through the bills throughout this webinar, but I just want to thank you all so much for being here. It's amazing what one can do when you turn adversity into advocacy. And I'm just proud of all the work we were able to do in the Michigan legislature last term. So thank you, Danielle.
Thank you. Thank you so much for joining us and for being here and for all that you do for the state. It is now my pleasure to introduce Dana Banda, a mom of 2 boys, one of whom was born via surrogacy. And after her own fertility journey, she's been really passionate about helping those who are currently in the trenches.
Hi, everyone. Thank you, Danielle. My name is Dana, and as Danielle said, my husband and I have 2 boys. We have a 4.5-year-old son who I was lucky enough to carry myself, and we have a 16-month-old who was born via surrogacy. He was born in November 2023. And we actually have a baby girl on the way. She's coming next month via surrogacy. She'll be born in Ohio. So we are so excited. We have a lot going on, but I've always been so passionate about talking about this subject. It's really complex. It's really challenging and very emotional. So anything I can do to help someone coming behind me is what my goal is. Our path to surrogacy was a little bit of a winding one. Like I said, I carried our first baby. So we went through IVF. It was, of course, hard. IVF has its challenges, but we did it. I was pregnant and I had an easy pregnancy. I carried him to term. It was boring, which is a good thing when you're pregnant. We didn't think anything of it once it came time for baby number 2. We went back to our clinic, and that's really when the trouble started. We went through many, many, many failed embryo transfers, many procedures, try to remove scar tissue. I had consultations with doctors in Michigan, in Boston, in New York, and nobody could figure it out. And it was really hard. It was one of the most devastating times of my life. I can still be emotional when I think about it. And it was during this time that my husband and my family really encouraged me to consider surrogacy, which at the time, it was a no. I said, I have done this before. I can do it again. I refuse. It didn't make sense to me that somebody like me could even need a surrogate. It felt like such a foreign concept. But it did become pretty clear from that point forward that if we wanted the chance to grow our family, that we would have to work with a surrogate. It was at that point we realized it was illegal here in Michigan, which, again, never in a million years did I think that paid surrogacy would be illegal. For what reason? It just didn't make sense to me, especially being one of 2 states, as Samantha said. Why Michigan? And it made an already complicated process that much more complicated. We had to get set up at a clinic in Connecticut. We had to wait for a consultation with the doctor there, which can take a lot of time. We had to ship our embryos, which was an added expense and very stressful. I remember the day they were shipped, I was tracking them from door to door because, God forbid, something happened to your very precious embryos that you spend so much time and money and tears over. And it was hard. And, I feel very passionate about the fact that if you have to go through something like that, when it's certainly not, the way you thought your family building experience was going to be, that at least it should be a little bit easier. And I remember when we were finally set up, we had met our wonderful surrogate, and our case manager at our surrogacy agency, who's also wonderful. She said to me at the beginning, I don't know much about your story yet. I don't know why you're here, but what I do know is this is not your first choice. And I understand, and I see that, and I respect that. And that really meant a lot to me because I felt seen, because this is such a unique situation that many people don't understand what it's like. So that was really important to me. So I'm just so honored to be on this panel, and I'm honored to be a part of this and to be a part of JFF. And I am always here as a resource for anybody that may need me.
Thank you. And thank you for being so open about what you went through. We really appreciate it and are very excited for you guys for next month.
Me too.
It is now an honor to be able to introduce the next two speakers, Stephanie Jones and Meryl Rosenberg. Stephanie Jones is the founder of Michigan Fertility Alliance and a dedicated mother of two. After experiencing a life-threatening pregnancy complication that left her unable to carry a child, she turned to surrogacy to grow her family. When she discovered Michigan's ban on compensated surrogacy, she made it her mission to change the law. Determined to make a difference, Stephanie founded MFA and got to work advocating for the rights of families like hers. Thank you, Stephanie. Meryl Rosenberg is an attorney in private practice who has assisted people in building their families through assisted reproduction, including with the help of third parties, and she's been doing this for over 30 years. So we're very excited to have both of you, and please.
Right. And I'm assuming they'll go ahead and share the screen for us. Here we go. Thank you so much, Danielle, for that introduction. And thank you to Rep. Steckloff. Obviously, I've got to know Sam very well over the years and have become, I would consider a good friend. And that's been through the sorrows and the trauma and the struggles of this journey to get this legislation passed. So I also want to share with everyone that this is the final webinar we're having before the MFPA takes effect on April 1st. It seems almost surreal to be on this call with you all tonight. It gives me kind of goosebumps to think about the years that have went into this. And just really grateful that everybody that's on this call tonight is a panelist, and also grateful for JFF for partnering with MFA on this amazing opportunity, and really grateful for everybody who took time out of their evening, which we know is hard, to learn about this law, because ultimately this is simply put to benefit people like Dana's family. My family would have benefited from this. I'm a mother, like Danielle said in my intro, a mother to two. I was able to carry my first child, lost my ability to have a child by my second pregnancy, and then needed to go through surrogacy. So we have just are grateful for everybody, and just grateful people don't have to struggle like we had to. So we'll get started. I'm also grateful to be here with Meryl. Meryl is just an absolute gift to everybody in this space. She's been doing this for such a long time. She truly cares. Not only is she an amazing skilled attorney, she's also an amazing human. So I will say that. And I know Meryl will drop her contact information. So if anybody has questions, feel free to reach out to her, because having a trusted legal resource in this space is critical. Meryl is also a licensed Michigan attorney, and you will find that that's critical to this law, since we will touch on this, but you must use licensed Michigan attorneys. So we have a lot to cover. So remember to drop your questions into the Q&A box as they come up. Don't wait till the very end to drop them all in, so we can make appropriate time based on the quantity of questions we're receiving. And actually, Elisa, who's on the call with us, who you'll hear her story, she's going to be moderating the questions. So we will get started. Like I said, my name's Stephanie. Meryl and I are going to be presenting. So Michigan Fertility Alliance, we are the driving force behind the Michigan Family Protection Act, which is a 9-bill package. And we'll go over that. And we represent families. We represent all families in Michigan formed through fertility treatments and assisted reproduction. And we are solely focused on and dedicated to policy reform and implementation. So we're a little bit of a different organization in terms of we don't offer support or anything like that. We would direct you to organizations like JFF for the support needs. We are solely focused in policy, because now more than ever, what happens at the state level is really what is dictating what happens in our lives when it comes to fertility. We work with experts like Meryl on this call. We worked with GLAAD, many other organizations in crafting this law. Really amplifying Michigan voices is really our goal. We pioneered Michigan's first infertility advocacy day in 2020, I believe. We had over 100 advocates. And really that was laying the groundwork for what the Michigan Family Protection Act. That's when Sam and I connected many years ago. So if you have the opportunity to join an advocacy day, you should, because they do matter. And Michigan Fertility Alliance is also proud to be one of the founding organizations of State Strong. We're a national pro-family policy movement. All right. So what is the Michigan Family Protection Act, or we'll call it the MFPA throughout this to kind of save ourselves a mouthful. But it's Public Act 24 through 32 of 2024. Those are the laws, if you're ever interested and want to read them. But it's effective April 1st, 2025. And really, it's for three very important parties. Number one, it's for children born through assisted reproduction. We remind everybody the MFPA is a child-focused set of bills. It is ultimately solely focused on protecting the vulnerabilities that children were currently in. Elisa, go ahead. Your hands up?
Oh, sorry.
Oh, okay. Sorry. No. So no problem. So it's protecting children, number one. So can keep that in mind. Currently, I know we are still actually under a law that leaves children very vulnerable, and we'll go through that. It's for parents, right? It protects the rights of parents to secure their rights to their children, no matter how they're born. And also for surrogates, we wanted to have a really robust law that gave surrogates the protection that they deserve. So if you hear the terms AR or ART, it's basically assisted reproduction, but ultimately means fertility treatments, IVF, surrogacy. Okay. So vulnerabilities before the MFPA, I'll just touch on this quickly. Ultimately, before the Michigan Family Protection Act, anybody who's on this call that wants to know about surrogacy knows surrogacy, compensated and contractual surrogacy, so civil and criminal surrogacy it was criminalized. So there was a ban on compensated surrogacy, and contracts were not recognized. That left children very vulnerable. And also, the critical part of the MFPA, it also has to do with parentage. So children born to unmarried couples, single people, same-sex couples, they had to go through a rigorous legal battle in order to secure the rights to their children. And that also included children born through surrogacy, even if it was a non-compensated surrogacy in this state. So many things are happening with this law. So takes effect on April 1st, just coming up. And that is just coincidental to the day it was signed. It wasn't meant that way. This was what they call a sign die law, which means it takes place 90 days. It's effective 90 days after the end of the legislative session. And that's just kind of how it ended. Here's us at the signing. Here's a family that Kevin, who's part of the MFA leadership committee, Kevin and his husband, they had transferred one embryo and got identical triplet little girls. So I know and they're wonderful. So this is, again, something you can read through this yourself, but it's really critical when we talk about parentage that you understand what that means. And ultimately, it means all the critical things that are available to your child, the decisions that need to be made, the critical decisions, it flows through parentage. So custody, access to parenting time, critical medical decisions, education, inheritance, social security, disability, so many things. So parentage is so critical, which that really doesn't get a lot of attention in this law because so many people refer to it as a surrogacy law, but really the parentage piece is actually bigger than the surrogacy piece. But we'll keep educating you on that. But just rest assured, you're going to be covered come April 1st. And then another one, pathways to parentage, obviously talking about birth, presumption of marital presumption, acknowledgement of parentage, which we'll touch on, assisted reproduction, and then obviously surrogacy, adoption, and so on and so forth. Again, you can read this slide, but we're going to be touching on children born through assisted reproduction and surrogacy tonight. And I will hand this over to Meryl, and she's going to take you on a legal journey. So get ready.
Okay, I'll try not to make it too technical. But also, I first of all want to say thank you for giving me the opportunity to be here tonight. It's really exciting because when I finished law school in Michigan, it was illegal. And even back then when surrogacy wasn't as known as it is now, and even when I started doing this 30 years ago, not in Michigan, the journey has been remarkable. So I feel like sort of like the grandmother right now, that this proud, it's an incredible time and moment. And I know Stephanie sort of shared this is true to my heart. And I work really hard with other people to advocate for changes in laws. And this, to me, to thank everybody who was involved in making this happen is just a remarkable piece of legislation to see. And it really did improve on the few statutes that are out there. And I do agree that it is the best of the best at this moment in time. So I'm so excited to be able to actually practice surrogacy in the state of Michigan after all this time. So let me tell you a little bit about it. So I don't need to really talk about the numbers so much, but it's been considered the main bill of the 9-bill package. Again, there's lots of protections in this package. And Stephanie already said it's the Assisted Reproduction and Surrogacy Parentage Act. So it adds the parentage protections for the children born through assisted reproduction, and for children born through surrogacy. And when we talk about that, next slide, thanks. It's important to think about the children throughout this, because I think sometimes what happens, and it happens to all of us when you're trying to have a baby, you're thinking so much about yourself, and we also have to think, the resulting child too is so critical, and is the reason that we're all here. So it defines assisted reproduction specifically as a child born as a result of the assisted reproduction or under surrogacy agreement, whose parentage may be determined under the act. And it's very specific what that means and what that looks like. It does state something maybe that's obvious, maybe not. It does not apply to the birth of a child conceived through sexual intercourse. Next, please. It also is really important, I can't stress this enough, that it defined who a donor is not a parent of a child conceived through assisted reproduction. It is an individual who provides gametes, that's sperm, eggs, embryos, for use in assisted reproduction, whether or not for compensation. It does not include the individual who gives birth to a child conceived through assisted reproduction themselves, unless we're talking about surrogacy. But again, the surrogate and the donor aren't always the same person, although it does cover genetic surrogacy as well. Next, thanks. It also clearly defines who an intended parent is. And some of this might feel obvious, but it's so incredibly important to have all of this carefully defined, as I'm sure the representative can talk about why that's so important. So it's an individual, this is really important, married or unmarried, who shows an intent to be legally bound as the parent of the child conceived through that assisted reproduction or under the surrogacy agreement, which we're going to talk about. And a parent-child relationship is established under the law. It is a natural parent for all purposes. And that's also really critical when you're talking about people conflate the issues between parentage and adoption, and stating that it's a natural parent for all purposes becomes really important in that scheme. Next slide, please. So this pertains only to children born through IVF, IUI, which is intrauterine insemination, and insemination. Next, thanks. So there are a few protections that are layered in the statute. One is the marital presumption of intended parents who are married. There is something I think Stephanie referred to earlier as an AOP, voluntary acknowledgement of parentage, for married or unmarried individuals. If that's applying in your case, the attorney helping you or others will be able to explain how that applies and how it doesn't. There's a birth record. It's really important to know that the birth record, birth certificate, is an administrative document and it reflects the parentage, but it is not a court recognition of that legal parentage, which is very critical, especially as people move around the country and elsewhere. You want to make sure there always is a judgment of parentage in any of these cases. So for the judgment of parentage, parents jointly petition for parentage, usually in a non-adversarial court proceeding, pre or post-birth. And often you'll hear people talk about a pre-birth order or a post-birth order. What they're really referring to is the parentage process that will result ultimately in a parentage order. And those who have gone through surrogacy know all about what I'm talking about, having gone through this process. And an intended parent may file an adversarial judgment where the consent might be disputed, where they have to show proof of consent. It also could come up in probate court where you're establishing a parent-child relationship for a decedent. Next. So what does consent mean? An individual who consents to assisted reproduction with the intent to be a parent is a parent of the child. And how do you show that consent? It's a recorded signed document, usually as an attorney, we like to see on record before birth. It could be on or after birth, depending on the situation. When we're talking about other situations, we're going to refer to an acknowledgement of parentage. Again, that doesn't apply in a surrogacy case, so I won't spend time talking about it. You can have an oral agreement before conception that they intended to be parents. I think having worked in this space for a long time, that is harder to show. And the best practices will always be to have some written intent. And ideally, that is prior to conception. And the court finding of a consent of an individual for the child's first 2 years has resided in the same household with the child openly and held out as their child. There was mention on an earlier slide of a de facto parent. So some of these things will apply across to other situations, and some things, of course, will apply only to the surrogacy situation. Next, please. This is what we were talking about in terms of an affidavit of parentage. Usually it's available at the hospital for assisted reproduction, non-surrogacy births. You can find it online. It's also available usually through child support program if the birth parent is mandated to cooperate with parentage establishment. And I do want to stress with this and other documents where it says it needs to be notarized, I get questions all the time, does it really need to be notarized? And the answer is yes. If there's a request for a notarization, that means we need it. Next, thanks. So the different ways to get that judgment of parentage we're talking about that's so important. The intended parent or the person who gave birth may initiate the process. Again, typically in surrogacy cases, it is the intended parents that initiate it, but we always have in our contracts, if it's not initiated by a certain point during the pregnancy, that the surrogate can initiate that process, depending on the state and the situation. It will be in the family division of the circuit court. If the individual is the parent, either because they gave birth or consented, the court shall adjudicate the individual to be a parent of the child. So again, these protections are right in the statute. It can be initiated before or after birth to obtain the judgment to declare the parentage and order that the rights and responsibilities, the recognition as parents, vest immediately upon birth. Again, with surrogacy situations where it's possible to do during the pregnancy, that is the preference, generally speaking. There might be some reasons why sometimes we see cases where you get a pre and a post birth. That usually comes up when intended parents are citizens of another country and need a post-birth order after birth with the name and the date of birth. So there can be situations that you would even end up with both. But for the most part, they are going to be during the pregnancy. I saw Lisa come on. I didn't know if where my time is, but I took a look. And the burden of proof is a preponderance of the evidence. So next, please. I'll try to speed up, I think. How can you use Michigan's law? Parentage can be filed in the county of the state in which one of the following: the child resides, is born, or will be born. I'll talk about in a second. A parent or intended parent resides. A proceeding has commenced for the administration of a state of an individual who is or may be a parent under the act. I do want to talk for 1 second about will be born. So I practice in other states, and that sometimes ends up being a little sticky because let's say your surrogate lives in another state and they think that's close. They think they're going to deliver in Michigan. I would guess that the court will want to see something that shows, good faith that the child really will be born there. We don't know how the courts yet will address some of these matters as they arise, but having dealt with those situations in the past, They do want to see some care with the Michigan OBGYN, the expected hospital. So it's a little bit more than just, we think the child will be born there. So next slide. Okay, so let's talk about children born through surrogacy. And I like the picture. I don't know, somebody can say if this was somebody who maybe went through JFF, I'm not sure.
This is Aubrey Goichai and her sister who cared for her. They're in Michigan, and Aubrey is part of the leadership committee. And
Perfect,
Aubrey
thank you.
had lost her ability to carry a pregnancy after having her first child and losing basically losing her uterus after that birth. So
Well, thanks. I always like to know who we're looking at and that it's somebody, and I like that it's connected with Michigan. Thanks. Okay, so next one. So this just gives you a little sense of where Michigan was and why this is so exciting. I'm sure everybody who's listening is excited, hopefully. So Michigan was the sole remaining state with the broad criminal ban. So had the honor of being the last state to get rid of that. Thank you for again the advocates who made that happen. And there's a trend around the country favoring regulating surrogacy. We see more and more states actually implementing and passing laws that regulate it in a positive fashion. There are 27 jurisdictions that permit or soon will permit surrogacy by statute, and it is growing. I did have the honor of working on and drafting the Model Act through the ABA that's been used through the years. And I will say Michigan definitely improved on it. This includes all states. And we have on here, recent enactment is Idaho, Oklahoma, Wyoming. DC was actually only in 2016. So Elisa did ask for me to say what that means by surrogacy by statute. So parentage is state by state and determined state by state, including surrogacy, and regulated state by state. But some states have accepted surrogacy, we call surrogacy friendly, through practice, some through case law. And now we see more and more that it's being regulated by state statute, by state law. But not every state that's surrogacy friendly has a surrogacy friendly statute. Sorry. I'm getting over a cold, so I apologize. I joke with you all. Sorry, I apologize. That's what happens when you talk a lot. So that's what that means when you talk about surrogacy by state law, by statute, I mean, versus perhaps it's case law or simply by practice. So if people have more questions about that, I'm happy to answer it. Next slide, please. Okay, so the law, I'm just going to call it the law instead of statute so I don't confuse people, but in this case, we're talking about the statutory scheme. As I mentioned before, authorizes genetic and gestational surrogacy arrangements and includes very specific protections and safeguards and requirements, which we'll look at the next slide. So we're going to go over a few of the requirements so that you all know, but the reason you work with an attorney who's going to help you through this is so you don't have to remember all these things. All the parties must be at least 21. They must complete a mental health consultation. Often you'll hear for the surrogate, it's referred to as an evaluation, and for parents, it's a psychoeducation, but it is a consultation. Every party must have independent legal representation. You cannot have the same attorneys. And this is very important. The attorneys must be licensed in Michigan. Not all the states require that. Next, please. Thanks. You will see, and anyone who's gone through this is familiar with knowing that the intended parents cover the fees and expenses for the surrogate, and that includes for her attorney. And the agreement, this is really important, must permit the surrogate to make all health and welfare decisions regarding the surrogacy and the pregnancy. And the agreement can provide for compensation, which we know is also critical for the people who decide to do this, the compensation really is for their time and effort for doing this. And it's important that they're able to receive remuneration for that. And I think the second statement is really bears focus on, because I do think it's hard. I think as Dana talked about in particular, you give up some control when you do this, and you're entering into a realm of something that you never thought you would have to. And even for people who always knew that they needed a surrogate, you still are trusting this person to carry your child and to take care of that pregnancy and that child. And you as parents, you give up control as an intended parent, and it is her decision how to make those health and welfare decisions regarding her pregnancy. Yes, you want to feel 100% confident and trust that she's going to take care of herself, but you need to know going into that that's going to be critical. Next, thanks. It's also important to know there are protections for how you can terminate the contract, very specific about that. And it also is so important that it specifically states that each of the intended parents will be a parent of that child. And as we said before, that parties can bring an action before, it says in the statute, on or after birth to abstain a judgment. I don't know that anyone's going to look to get a judgment on birth, but it really will, for the most part, we're going to see it before. And it is important to know, I think this is true anywhere, it's not going to be effective until birth, because that's when it's going to be utilized. So even in states that don't require, there's some states that require a validation after birth. It's not critical that that's, a requirement, because that's when it'll be stated that that's when it's effective. Next, please. This is also important. It must be completed before transfer. I have had cases over the years that have said, we didn't realize we needed a legal agreement. They may be working with physicians that weren't doing all the checks and balances, and they've entered into agreement after transfer. We really hope nobody will try to do that in Michigan. Again, it's very clear. We talked about the gestational carrier. GC is referred to gestational carrier having rights to make decisions about her care. But there will be protections in the agreement about impact on the child. So I don't want anybody going into this thinking that they have no protections for themselves vis-a-vis the medical decisions. No fertility center should move forward without what we call a legal clearance letter to proceed, meaning everybody has complied, entered into the contract that is very specific, has executed it, will be required to be notarized, and everybody has signed that appropriately. Elisa, do you have a question? Oh, sorry. And again, this mentions it's, sort of around when we try to start it. I try to start it earlier, usually right at 18 weeks, so that we have time to get it all done, because people sometimes take a long time to get paperwork back. And again, we talked about the use of Michigan attorneys. Next, please. You are absolutely permitted to use what we call matching services, matching programs. They are called agencies, so that's what you're going to hear, but often I will talk about matching programs. They can be anywhere. They don't have to. I always say where the matching program is not what is so important. It's where the gestational carriers are, surrogates are, where they're coming from, and what's important to the intended parents. And matching programs should do the proper vetting, and that's for another webinar and what that looks like. But every fertility center has their own screening protocol, hopefully following the American Society of Reproductive Medicine's guidelines. That's who issues the guidelines in this space. There are a few that don't, but I personally don't, really work with fertility centers that don't. But you're still going to have to comply with the requirements of the law. And there are a lot of what we refer to as independent arrangements. You don't have to use a matching service, but in any case, you should retain an attorney, and I recommend early on, that will help steward you through what are the requirements, what are the things you should be looking for ahead of time. Perhaps they can even help you do some of that vetting before they're even medically screened by your fertility center. And also that they're looking at the important other details it mentions here, like health insurance, which is so critical. And I know more about health insurance than I ever wanted to know. We still work with professionals around that, and I know what I'm looking for, but it's incredibly complicated and incredibly important to understand what the surrogate's insurance situation is before you get started, and so that you know what needs to be put into place. Also, life insurance is always going to be part of the agreement. And ideally, that will be put into place before she starts medications. There are a lot of reasons why, and we can go over that another time. And you hear, there's mention here of an escrow. You must be using an escrow account. That way, everybody's protected. The funds are in place. There's an easy way for the gestational carrier to get her fees and expenses paid or reimbursed. And it's a very clear way that everybody's protected and knows where the funds are and that they're there and ready to go. Next slide. Okay, I thought I had one more, but that's great. We have, oh, perfect. We exactly 15 minutes for questions. But I do want everybody to take our contact information. I never mind having a conversation with anybody about any questions they have, how to navigate this process, even connecting with other professionals that they need, or people like the parents through surrogacy that are here that are always willing to help. And just a little bit, I actually helped bring JFF I didn't say this, in the Maryland, DC area, and I have served on the board. So I'm very familiar with JFF, and that too is, true to my heart. So I'm so happy to be part of this tonight and look forward to the questions. Thank you.
Wow. Thank you both so much. My brain is very overloaded, and I'm very excited to actually review this recording and take all of it in. We're so appreciative, Stephanie and Meryl, for everything that you shared with us and for your input. And right now, I want to introduce Elisa Stern. She is a parent through surrogacy to a very adorable little boy. She's a social worker licensed in Michigan and New York with a private practice focusing on gestational surrogacy. And she's also a director of clinic quality assurance at Ohio Children's Home and Family Services. And so Elisa is going to be leading our Q&A. So again, if anyone has questions, please put them in the Q&A box, and I'll give it over to you.
Thank you. I'm going to start with a question of my own as somebody who worked with a gestational surrogate in Illinois. I'm curious how our laws compare now to Illinois and Ohio.
Great question. So Illinois, actually, I should remember the year when it passed. It's a different type of a statutory scheme, and sort of it has a lot of protections in it. It has an administrative pathway and also a court process. So you actually don't have to do the court process in Illinois. Many people choose to do that for various reasons, but this package is much more comprehensive than just the Illinois Surrogacy Act. Now, I would have to literally do a side-by-side comparison, which I don't think I can do right on one foot, but this is definitely more comprehensive than that was. And it's not that that didn't seek to be, it's just, I think at the time when it was passed, the thought about what should go into a bill was not the same as it is now. And they were not correcting a situation that existed in Michigan. So I think the challenges and the reason behind the law was different. Ohio does not have a surrogacy statute like this. It's been practiced in, Ohio is very surrogacy friendly. I think Dana said your surrogate was born in Ohio. It's very surrogacy friendly. I work with those Ohio attorneys all the time, but it doesn't have the same framework that Michigan does. But it just shows you how every state is different and why it's important to talk to, an attorney who knows the laws of that state if you're working with a surrogate from that state. And by the way, this is incredibly exciting. It doesn't mean the other avenues are closed. Of course, it just broadens the ability to have that choice of working with someone in Michigan and using the Michigan protections for the citizens that live there. And I know Samantha would be happy that more and more I always say Michiganians, and that's bad because I live there. I know, Michiganders, sorry. But anyway, I don't know. Someone miseducated me. I saw that face.
We forgive you, Meryl. But I do want to also add on something that Meryl said, is to remind everybody that, every single state is nuanced in how their legislative process works and the law and the way the laws are written. And, when we started working on the MFPA in terms of Michigan Fertility Alliance, we really built a umbrella of experts. And we actually leaned on Courtney Joslin, Professor Joslin from UC Davis, who is the reporter, one of the head people on this thing called the Uniform Parentage Act, which is a bipartisan framework model law that we were able to pull from that has been updated recently as 2017. So that's why we took the approach that we were going to help as many people as possible with the MFPA. So when our advocacy first started, we were very focused on surrogacy, and we grew that to parentage because we knew that it was critical that there were so many vulnerable children born in our state that weren't born through surrogacy, but born through assisted reproduction, that we wanted to also help them, especially to children born to same-sex couples, and the critical aspect of allowing them a pathway to parentage than having to go through second parent adoption, which can leave children vulnerable for a long time. Same thing for unmarried parents. So I wanted to add that. The parentage component is actually quite unique to how the MFPA was done. So.
And I just want to add on, and I don't know, where everybody is in their specific journeys that are participating in this. And I know that there's a focus on surrogacy, but what Stephanie said right now is so important, because there are states that have put into place what we call confirmatory adoption laws. That's not the same thing. It's still an adoption of your own child in a way. It's made it easier. And Michigan is really, I feel, light years ahead by framing it the way it should be.
I have a question to dovetail on that. So will intended parents be on the birth certificate in Michigan starting from April 1st?
Yes.
Oh, okay.
A big fat yes. If they go through the right process, I should say, yes.
Yes,
Right,
thank
that's
you,
a big
Meryl. I was
deal.
going to say, we cannot stress that the law is very clear. And we have actually, the Michigan Fertility Alliance has trained the Michigan Judicial Institute, which is responsible for the continuing education of our judges, our magistrates, our referees, every court administrator. And we have trained them on the nuances of this law down to the word. So you must follow the law to get the outcome you want. So it's very clear, it's easy to follow, but that is why what Meryl is saying is so important, that you consult attorneys and legal professionals early on in the process to make sure you don't find yourself in a position where you're having to go above and beyond, because the goal with the law was to also keep it so people's legal fees were at a manageable level, so on and so forth. So you're not going through this adjudication process by not following law. So just follow the word of the law and you'll be good to go.
Right.
So you're saying that this law has a bumper bowling element?
What'd you say?
I said, it sounds like this law has like a bumper bowling element. Yeah.
I have to think about that.
You don't have to go way out of your way legally.
No question. I mean, you can do it after birth, and it depends. If somebody for some reason waits a long time and does it later, you're going to have to fix a birth certificate, but that's not the goal, and that's really not how it should happen.
Now, will there be a difference if there's a genetic connection to the child?
So the law does cover genetic surrogacy as well. And so the statute is very specific about each type of surrogacy and what path you need to follow.
That is unique also, and Meryl can say that another kind of component of us really making this tent of people that could give us input. We are seeing more and more genetic surrogacies in our country for many, many reasons. A lot of times the carrier also was going to be the egg donor, so why not just bypass the process? And also less expensive, less medically invasive, whatever the case is. So we really want to make sure that children born through genetic surrogacy were also protected. We actually had a handful of families that were part of MFA and advocating who their child was going to be born through genetic surrogacy. And it was really critical to make sure that everybody was represented in this law. And that's what we're also proud of.
Thank you. Different question coming through. And one moment. If there's one main thing that we can take away from this act, and from where our state is with its legislation, what would it be?
I feel like I want to defer to Stephanie and Samantha because they were I was in the background giving some input for however many years, but they were on the front line. So I'm going to let them.
Yeah, I want to jump in on this one. What we were able to do in Michigan is kind of unheard of. When I first began and I said that we have the most updated parentage laws in the country, I was being serious. There is a reason you did not really hear about this bill package as it was moving through the legislative process. The whole parentage surrogacy idea can be very political. And we had some very, very difficult and uphill battles to face. Now, for everyone on this call, it might seem like, how is surrogacy illegal in Michigan? How is it criminalized? Well, this goes back to where we are. A good example is when we were putting this together, Right to Life, the Catholic Conference, they truly and honestly believe that an embryo is a person. And so we had to kind of massage that a little bit. And the reason it was so kind of stealthily done is we made sure the bill package was perfect. We were suspending rules left and right. We kind of had to sneak this through because there's two sides of this argument. We have the extreme left, who says this is human trafficking, and we have the right, who says an embryo is a person. There was articles put out about me after the legislation passed out of the House. Right to Life and the Catholic Conference put out an article that said God never intended Steckloff to be a mother. So there was a lot of like difficult and evil frameworks we were kind of working up against. So Stephanie and I mean, when we say we worked hand in hand on this, I mean, we really worked hand in hand on this. So it might seem like this was this easy process. It was so difficult. The way Stephanie and I had to maneuver this bill package is something that I've never seen go through any state legislature this way. We were on top of it. We were prepared. We were ready. We had all of our ducks in a row. We had testimony ready to go. And it was very difficult. And then in January, the whole Alabama case happened. And I think that's what really helped propel this bill package to move so quickly, because as soon as that happened, we got it through the Senate, it was signed into law within 3 months. I mean, again, this process is unheard of. So that's why there's so many questions about this 9-bill package. There's 9 bills. Not only does it have to do with, birth certificates, but inheritance laws. The decriminalization of surrogacy was only 1 bill. And so that is why it's so important and why we're spending so much time educating not only the public, but judges, attorneys, and lawyers, because it was done purposefully this way, because it was the only way we could get it through.
Your one word is comprehensive.
Yes, very comprehensive, very comprehensive.
It's hard to pick a one word.
Thank you.
Stephanie, we can't hear you. I think Stephanie.
Sorry, I said the one thing I want people to hear and take away from what Sam just said and hearing, what I'm sharing with you is I'm a volunteer to the Michigan Fertility Alliance. So where there's a will, there's a way. We did this up against, the odds were stacked against us, well-funded, ivory, kind of offices, all of the things against us. And we did this in a ragtag, bootstrap,
Really was.
never take no kind of way. And that's the best way I can say. So if you see something, you can fix it as a citizen. You just have to start.
Yeah.
That's a very empowering message for all of us. There's another question that came through. Because of the expense of surrogacy, is there any financial assistance available?
Well, someone's going through a JFF Foundation grant right now. That's what I'm looking at. My plug to all of you.
Yeah, thanks for saying that. I believe that to answer that question, like please reach out to Taylor to see if you qualify, if anyone's going through that qualifies for a grant with JFF. And then I don't know if Stephanie and Meryl or Elisa or Dana, if you have other organizations or other resources. I know Taylor might also.
I'm sure Taylor can. There are some resources. That's one of my biggest like pet peeves and goals is to try to find more and create more. And the Academy of Adoption and Art Attorneys is putting together a comprehensive resource list that we will certainly make available to JFF when we have it. But there are the Hebrew Free Loans. I mean, there's other resources. It doesn't ever feel like enough because it is quite expensive. I know some fertility centers have their own plans and provide some discount. They have their own sort of grant process internally. There are loans and grants, and I know people aren't looking to incur more loans, but sometimes that is helpful. So there are some resources out there that I don't mind working with JFF to try to give you a more comprehensive list.
I want to also recommend that if anyone is interested, look into some of the Facebook groups. There's a particularly helpful group called Intended Parents Through Surrogacy. And I think they keep an updated list of companies that you can work for that offer some kind of a subsidy. And some companies offer a little bit and some companies offer a lot. And I think that, it's definitely something to consider looking at. Because this is a project, and sometimes it's a multi-year project to get to where you want to go, and that might be part of the calculation.
And I do just want to add something to the question about just the expense of surrogacy. I know firsthand how expensive it is, and also just how financially inequitable infertility is as a whole. And I would urge you to make sure you follow along Michigan Fertility Alliance. You can go to our website, Michigan Fertility Alliance. You can follow us on Facebook, on Instagram. We do a wonderful newsletter where we're sending it at least once a month. Sometimes you get one once a week. It's like a surprise. That's what we always say. It's always when we have something to talk about. But, we are actively working on getting insurance coverage here in Michigan for infertility care, which is for most people in the state, it is not covered. So if you really want to advocate and join our efforts, that is where the next big push is going to be. We have no idea what the kind of timing looks like for anything like that, but we just want you to know that it's going to be important. So follow along our journey and we'll let you know when we can, use or need the assistance. And I can't say much more than that other than get ready.
I want to thank everyone here, all of the attendees, all of the panelists, Elisa, Dana, Representative Samantha Steckloff, Stephanie, and Meryl. Thank you so, so much for your time, dedication, and passion for making this a reality. And for anyone out there, if you have questions, follow-up questions, please reach out to these experts. We really appreciate it. And thank you. We hope you have a great night.
Thank you.